Hello, class. Today, I would like to talk to you about or discuss the criminal justice system in Texas. If you have your key terms, then you can pull them out and follow them with me as I go over them. Or if you do not have the key terms, then you can always go to Canvas and download them. But for now, I would like to discuss the criminal justice system in the state of Texas. In Texas, as in other states, you have a system whereby if individuals have disagreements, they can go to court to have those disagreements ruled upon, decided on. In Texas, we have criminal justice system, which talks about what happens when people are accused of disobeying the law, accused of committing crimes. Criminal justice system. Now, criminal justice system involves determining whether criminal law has been violated. Does not involve whether or not civil law has been obeyed. Civil law is when civil law is utilized in civil cases, and that is when two individuals have a disagreement and one individual goes to court and files a suit against the other individual. Two parties, plaintiff versus the defendant. Plaintiff is the one that files the lawsuit, and the defendant is the one that the lawsuit is filed against. Plaintiff has the burden of proof, and that the plaintiff has to prove his or her case against the defendant. Civil law would be, examples of civil law would be torts, tort law or family law. Tort law concerns when a person has injured someone else, and that injured party sues the person that the injured party claims injured him or her. Like, for instance, a person is in a store and that person slips in the store. Person claims that he or she slipped because of the negligence of the storekeeper or the negligence of the person that managed the store or owned the store. Unsafe conditions in the store. That would be an example of a civil case whereby civil law would be applied. Or a person is in a restaurant and that person consumes something that injures that person, or person drinks coffee that's too hot. Person maintains that he or she was injured because of something that the other party did, or the failure of the other party to maintain proper care, or maintain reasonable care inside of the store with respect to that product. Things of that sort. That would be tort law. A person, unlawfully touches another person, falsely imprisons a person. All of those would be examples of tort law. Family law deals with matters concerning divorces or child custody. or child support, matters affecting parent-child relationship. All of those are civil law matters, civil cases. All of those are family law cases. All civil law cases are settled in civil courts. Settled in civil courts. And it is determined whether or not the defendant owes something to the plaintiff. Those are civil cases, and civil courts handle them. Criminal law is a different matter. Criminal law pertains to whether or not a person has violated a law, broken a law, and whether or not that person should be forced to stand trial for violating a law. Person put on trial, and that person, goes before a judge or a jury, and either the judge or the jury determines whether or not that person has violated the law. So that's the difference, one difference between civil cases and criminal cases. Also, let's say a person is made to stand trial in a criminal case. Prosecutor prosecutes that person. That prosecutor, first of all, has the burden of proof. Prosecutor represents the government, and the prosecutor has the burden of proof in that criminal case. That prosecutor has to prove the case against the defendant. The defendant, if he or she wants to, they can just sit back and watch the prosecutor at work. They could simply do nothing. The prosecutor has the burden of proof. Just like in a civil case, the plaintiff has to prove the case against the defendant. And the defendant can just sit back and watch the plaintiff prove the case in court. Now, when it comes to a civil case versus a criminal case, the people that are proving the cases, the plaintiff in the civil case and the prosecutor in the criminal case, they have different burdens of proof. What are the burdens of proof? In a civil case, the plaintiff has to prove his or her case by a preponderance of the evidence. And what that means is that they have to show that it is more likely than not that the defendant has done them the wrong that they are claiming that the defendant did. More likely than not. 51%, not 51, but more than 50% of the evidence has to favor the plaintiff. More than 50% of the evidence has to favor the plaintiff. Preponderance of the evidence. If more than 50% of the evidence, let me rephrase that. If the evidence favoring the plaintiff is not more than 50% of the evidence presented, then the plaintiff loses. For instance, what if the evidence were 50% favoring the plaintiff, 50% favoring the defendant, evenly split? In that case, the plaintiff loses. The defendant wins. Preponderance of the evidence. That is what's required in a civil case, and the plaintiff has the burden of proof. Now, what about a criminal case? Prosecutor has the burden of proof, and the burden of proof is higher, much higher. The prosecutor has to prove his or her case by beyond a reasonable doubt, by proof beyond a reasonable doubt. The prosecutor has to prove his or her case by proof beyond a reasonable doubt. What does that mean? It means that the overwhelming majority of the evidence has to favor the prosecutor's side. The overwhelming majority of the evidence has to say that the defendant is guilty. What if you had a situation where 55% of the evidence favors 55% of the evidence favors the prosecutor's case, 45% of the evidence favors the defendant's case? Defendant wins. That is not beyond a reasonable doubt. What is required for beyond a reasonable doubt? Overwhelming majority. What about 75% favoring the prosecutor, 25% favoring the defendant? Not good enough. That is not proof beyond a reasonable doubt. Now, it is my contention that the evidence has to be at least 90% in favor of the prosecutor's case. At least 90% in favor of the prosecutor's case. Now, that seems like a high number, a high percentage of the case, a high burden that the prosecutor has to prove, high percentage. Do not kid yourself. Do not kid yourself. Prosecutors have had no trouble in having defendants convicted, in getting defendants convicted. What is the rate? 82% conviction rate in Texas. 82% conviction rate in Texas. And that's even when you have jury trials. I believe that juries are even more prone to convict defendants than judges are. 82% conviction rate. What does that mean? That means that 82% of the time, the prosecutor is able to win their case. It's more likely you have a better chance of having a hung jury than you have of being found not guilty. A better chance of getting a hung jury than you have of being found not guilty. And then when you have a hung jury, what happens? It's strictly up to the prosecutor. The prosecutor can retry you. If you are not exonerated, if you are not found not guilty, but instead the jury failed to reach a decision, and that's a hung jury, failed to get 100%, because that's what you need. Jury has to come up with a unanimous verdict in a criminal case. So if that happens, prosecutor can retry you, but the prosecutor may want to rethink that because it costs money to try people. It costs money for trials, and if it's not a overwhelmingly important case, then the prosecutor may not retry the case. And then in that case, the defendant gets to go home, and that's it. That's the end of the case. That's the end of the case. Now, criminal case, the government brings a case against the defendant, and the defendant first has to be indicted or formally charged, and then the defendant is put on trial, made to stand trial. And if the defendant is convicted, then the defendant is either incarcerated, or if it happens to be a capital murder case, the defendant is guilty of capital murder, and we'll talk about that later, then the defendant can be sentenced to death. Sentenced to death. And you have all of the appeals that can take place. Now, the criminal justice system, when it comes to prosecuting individuals for committing crimes and adjudicating guilt or innocence, and then punishing that person. The criminal justice system has 3 important goals. Punishment. Of course, we want to punish people for committing certain crimes. Deterrence. Punish people for committing certain crimes, and also punishing people that, commit wrongs against other people in civil cases. We want to punish those people through loss of life, liberty, or property. Or through loss of liberty or property, or in some cases life. Punish that person. So punishment is very important. You do something bad, you're going to get punished. Deterrence. We want to deter other people from engaging in the same type of behavior. Deter you, but we also want to deter others. That way we protect society. Protect society. So, punish a person for committing certain acts, deter others from committing that same type of act, and we want people to change their ways. A person is convicted of a crime, we punish that person. We want to deter others from committing the same types of crimes or committing the same acts. And we want people that we punish We want them to become better people later on. We want to rehabilitate those people, people that are not sentenced to death, that are people that we incarcerate. We want that person, when they get out, to be better people, to become a better person. We want that person to become a better person, to mend their ways. Rehabilitation. When a person goes on trial in Texas, go to court, prosecutor presents their case, there are certain rules that both sides must obey. Discovery. Both sides are entitled to certain information from the other side, information that is subject to discovery. You have a process whereby juries are chosen to judge cases. The petty jury chosen to hear the case and decide whether or not a person is guilty. Certain procedures that have to be followed in criminal cases. The Texas Code of Criminal Procedure. The certain process that has to be followed in conducting a criminal trial. The Texas Code of Criminal Procedure. And of course, for a civil trial, there is the Texas Code of Civil Procedure. One of the requirements in a criminal case is that, and this has a lot to do with discovery. If the prosecutor comes into the possession of evidence that's favorable to the defendant, then that prosecutor has to give that evidence to the defendant or the defendant's attorney. That is known as exculpatory evidence. If the prosecutor comes into the possession of certain information, certain evidence that's favorable to the defendant, then the prosecutor is supposed to. Now, that's not to say that the prosecutor will always do that. We have some corrupt prosecutors. We have some corrupt prosecutors that are guilty of misconduct. But they are supposed to give up that information to the defendant or the defendant's attorney. Texas Penal Code, we have a set of guidelines that includes prohibitions and penalties and correctional measures. It's a book that's called the Texas Penal Code. It tells about all the different crimes and the possible punishments for those particular crimes. The Texas Penal Code. Now, if you commit a crime, then you're going to be punished. What is your punishment going to be? What should your punishment be? What should your punishment be? Let's say that I'm in a store and I shoplift while in the store. I steal an apple. I steal an apple. On the other hand, there's another person that's in a store and that person robs the store, armed robbery. Both people, I said, I should have mentioned somebody else, not me. I wouldn't do anything like that. But one person steals an apple, another person robs a store. Both guilty of crimes. Do both merit the same punishment? The answer is no. One is considered a misdemeanor, and the other one is considered a felony. So there are different punishments for different crimes. That's what you call graded felonies. You have first-degree felony, second-degree felony, third-degree felony, capital felony, state jail felony. And then on the other hand, you have misdemeanors. You have Class A misdemeanor, Class B misdemeanor, Class C misdemeanor. Different penalties for different crimes. Those are called graded penalties. Graded penalties. Now, like I said before, misdemeanor, big difference between misdemeanor and a felony. Felony, much more serious crime. Much more serious than a misdemeanor. Misdemeanor, less serious crime. Let's say, for instance, a person is put on trial. You have two people put on trial for the same offense. One person is, let's say both people put on trial for the same offense. Both people convicted, same offense. One person has priors, has been in trouble before with the law. The other person, before now, was clean. That person that had priors, that person is going to be subjected to what is known as enhanced punishment. Enhanced punishment. And what is meant by enhanced punishment is you are convicted of a certain crime, then as far as punishment is concerned, you're going to be treated as though you are guilty of the next higher crime. Like, for instance, convicted of a crime that's a Class B misdemeanor. When it comes to punishment, you are going to be punished as though you were convicted of a Class A misdemeanor. That happens when you have prior criminal history. Also, if you're a member of a gang involved in organized crime, or you are convicted of what is known as a hate crime. So, prior record, member of a gang, convicted of a hate crime, you are subject to what is known as enhanced punishment. Enhanced punishment. Incarceration, that's when you're convicted of a crime and you go to jail or go to prison. Incarceration. Texas has one of the highest incarceration states in the nation. Texas has the second highest incarceration state has the highest incarceration rate in the nation. Louisiana is the only state that has a higher incarceration rate. some people, when they go to court and stand trial for serious crimes, and they are convicted for what is known as capital felonies. Capital felonies. For a capital felony, you can be sentenced to death. You can be given the death penalty. You can be given capital punishment. And what happens is that, in Texas at least, the jury has to go through a set of facts and answer yes or no. And if they answer both questions in a certain way, then you can be sentenced to death. They answer a question concerning, are you a continuing danger to society? Yes. If they answer yes, and then they ask the question, are there any extenuating circumstances in your case? If they answer first yes, and they answer the second question no, then you can be given the death penalty. You can be given the death penalty. Yes, no, you can be given the death penalty. Capital punishment, death penalty. Texas has the highest rate, the highest capital punishment rate, more than any other state. And it's been that way for a while. And it's been that way in Texas, even though I suspect, even though I don't know, I suspect that innocent people have been convicted of crimes and have been put to death. They have been convicted of crimes that they did not commit and have received the death penalty, and they have been convicted. One thing about the death penalty, if a person is wrongly committed or convicted of a crime, and it's later discovered that that person was wrongly convicted, then that person can be set free, and they can do things to compensate that person for the wrongful conviction and the wrongful imprisonment. And I think in Texas, you get something like $80,000 per year for wrongful imprisonment. But if you wrongfully convict and execute a person, what are you going to do then? What are you going to do then? So, capital punishment is a popular form of punishment in Texas. Popular because it's said that a lot of people that are sentenced to death, they really deserve it because of the heinous crimes that they have committed. But you have to be certain. You have to be sure that that person actually committed that crime. And there are some restrictions on the death penalty, on capital punishment. First of all, at one time the Supreme Court, and the U.S. Supreme Court back in 1972, outlawed the death penalty because at the time the death penalty was being administered in a capricious way, no set standards, giving the death penalty mostly to people of color, not white people, but people of color mostly. Now, I'm not saying always the case, but mostly to people of color. So the Supreme Court determined that the death penalty being administered that way was cruel and unusual punishment, and it was outlawed. But later on, it was reinstated. But Furman versus Georgia, 1972 case, Supreme Court outlawed the death penalty, ruled that the death penalty was unconstitutional. Furman versus Georgia. Also, because of a Supreme Court case, Roper versus Simmons, death penalty cannot be administered to people who were under 18 when they committed the crime, committed the capital felony. Also, because of Roper v. Simmons versus Simmons, life imprisonment without the possibility of parole cannot be given to a person who was under 18 when they committed the crime. Also, there's a case that whereby the death penalty cannot be given to a person who was mentally retarded, cannot execute a mentally retarded person. And now, cannot execute a person that's mentally retarded cannot be executed. Roper v. Simmons also said that you cannot give life imprisonment. You cannot give life imprisonment to people who were under 18 when they committed a crime. Cannot give life imprisonment without the possibility of parole. Now, if a person commits capital murder, that does not mean, and that person is not given the death penalty, that does not mean that that person is going to be treated leniently. That person more than likely is going to spend the rest, no, not more than likely, that person in Texas will spend the rest of their life in prison. Life imprisonment without the possibility of parole is what a person that commits a capital felony and does not get the death penalty, that is what they wind up getting. That is what they wind up getting. Life imprisonment without the possibility of parole. So that's what happens when it comes to capital punishment. You commit a capital felony, and certain crimes they define as capital felony. Killing of a police officer in the line of duty, killing of a fireman in the line of duty, premeditated murder, murder for hire, all of those considered capital felony. And the perpetrators are subject to capital punishment. Okay. Let's say you commit a crime and later on you commit the crime and you're convicted of the crime, but you don't want this crime to be on your record. Then you can go to the governor and ask the governor to give you a pardon. Commit a crime, you're convicted, and then later on you can You can request a pardon. The governor can't give it on his own. He's going to have to do it only if it's recommended by the Board of Pardons and Paroles. Board of Pardons and Paroles recommends that the governor pardon a person. Then the governor can. Doesn't mean the governor has to, but the governor can pardon a person. The governor can also commute a sentence if it's recommended by the Board of Pardons and Paroles. Okay, pardon is the forgiving of a crime. The forgiving of the sentence for the forgiving of the commission of a crime. Commute means you are reducing the sentence for a crime. You were convicted of a crime, and you were sentenced, and then you receive a commutation. The governor can do that if the Board of Pardons and Paroles recommends it. Reduction of a sentence. That can also mean, instead of getting the death penalty, you get life in prison. The death sentence is reduced to life imprisonment. Commutation, reduced punishment. Now, reprieve. Reprieve is like a stay of execution. Now, the governor can do this on his own. 30-day stay of execution. Does not have to go through the listening to the Board of Pardons and Paroles. Can do that on his own. One time stay of execution. One time stay of execution. The governor can do this on his own. Now let's say a person is convicted of a certain crime, and that person is later found to be innocent. That person is later on exonerated, and that person is let go, allowed to go free, and that person receives some type of compensation, educational benefits, healthcare benefits, receive those things from the state. Recidivism. Recidivism rate in Texas is pretty high. That's when people, they commit crimes and they are punished, and then later on, they commit crimes, they are punished, incarcerated, later on released because they completed their sentence, or they received parole, and then the person proceeds to commit another crime. Repeat offenders, 25% in Texas, high rate. Now, can something be done about this? Well, education has been found that education would benefit these people, because it's found that people receive education, then they're 50% less likely to repeat crimes, to commit crimes in the future. Education. Education reduces the likelihood of repeat offenders or recidivists. Parents' patriarch. Parents' patriarch only refers to situations where it says that the state has the inherent authority to act on behalf of individuals who are not capable of protecting themselves. They protect individuals who are not capable of protecting themselves. Parens patria. In loco parentis, the state taking the place of the parent. Taking the place of the parent. There's a certain age in Texas whereby everyone, they are totally responsible for their actions. They are made to be held responsible for their actions. And in Texas, that is known, well, it's known as the age of majority. And in Texas, it is 17 years old. In Texas, it is 17 years old. Now, that does not mean that if you're under 17 that you're not going to be punished for crimes. I mean, there's always juvenile. There's always the juvenile system. And in some cases, even if you are under 17, in some cases, if you are at least 14 years old in Texas, then you can be tried as an adult. You can be certified as an adult and tried for committing a crime in the state of Texas. And of course, there's the juvenile system for people of a certain age that commit crimes. Now, if you are 10 years old, if you are under 10 years old, you cannot be prosecuted for a crime at all. If you are 10 years old or under, you cannot be prosecuted for a crime. If you are 10 years old or under, cannot be prosecuted, not even in juvenile. No prosecuting of people under 10 years old. That doesn't mean that they won't try to go after the parents. They will go after the parents. They will at least attempt to go after the parents. The juvenile law, set of laws pertaining to how juveniles are to be treated, and usually juvenile, they are prosecuted under the Code of Civil Procedure, not criminal procedure, but civil procedure, juvenile law. And the emphasis on juvenile law, they do punish, but the emphasis lately on juvenile law has been to try and rehabilitate juveniles. Rehabilitation. Roper v. Simmons, like I said, Roper v. Simmons was the case that said that people under 18 cannot be sentenced to death. People that commit crimes under 18 cannot be sentenced to death and cannot be given life imprisonment without possibility of parole. Bill of Rights. The Bill of Rights are those first 10 amendments to the U.S. Constitution that talks about certain freedoms that people have. Certain freedoms that people have. Now, when the Bill of Rights came into existence, 1791, from that time, for a long time, it was determined that the Bill of Rights only applied to federal government actions, not state government actions. It was like that until the 14th Amendment was ratified. Until the 14th Amendment was ratified in 1865. The 14th Amendment, one of the provisions of the 14th Amendment was that a person cannot be deprived of life, liberty, or property without due process of law. The Supreme Court has taken that due process clause of the 14th Amendment to mean that most of the Bill of Rights, not all, but most of the Bill of Rights applies to federal government action. Most of the Bill of Rights applies to action by the federal government. Not all, but most applies to action by the federal government. One portion of the Bill of Rights is the Eighth Amendment to the U.S. Constitution, which says that a person should not be subjected to what is known as cruel and unusual punishment. Cruel and unusual punishment is forbidden. The government cannot impose it. Now, today, because of the 14th Amendment, and because of the fact that most of the Bill of Rights, which includes the Eighth Amendment concerning cruel and unusual punishment, applies to state action. States cannot subject its residents to what is known as cruel and unusual punishment. Cruel and unusual punishment. It has been determined by the courts that overcrowding in prisons is a form of cruel and unusual punishment. And when that happened in Texas, Estelle versus Ruiz, then the state of Texas was forced to build more prisons to reduce the overcrowding, to get rid of the overcrowding, to eliminate the overcrowding. Now, I think I mentioned before the fact that we have some unruly prosecutors, people prosecuting cases. You know, like I said, they are supposed to surrender to the other side, to the defendant or the defendant's attorney, any exculpatory evidence that comes their way. But they don't always do that. We have had cases where prosecutors hid such evidence. We have some bad prosecutors in the system. We have misconduct in the criminal justice system. Prosecutors withholding evidence, tampering with evidence in the crime lab, things of that sort. There was I remember one time where not all, but most cases had to be thrown out or re-examined because of the problems with the crime lab. What happened in the crime lab? Pro bono representation. Pro bono representation is simply free or inexpensive representation. Free or inexpensive representation. You have some attorneys that offer pro bono representation. Representation for free or representation for a reduced price. Representation for a reduced price. So, that's it. That is the discussion that I have for you concerning the criminal justice system. You're going to now proceed to take a quiz, 25 questions on the quiz, and that'll be it. That will be it. Okay, well, you can take the quiz on the I think it's scheduled for the 28th, if I'm not the 28th. It's on the Canvas. Just go to Canvas, it'll tell you when the quiz is due. And there are 24 questions, 25 questions on the quiz. It's not a difficult quiz. And this quiz is going to be worth a little more. Instead of 10 points, it's going to be worth 15 points. Instead of 10 points, it's going to be worth 15 points. Okay, well, you're going to have a nice day and take care.